Welcome back to the Business Immigration Benchmark. Today I have a very special guest, Leiza Dolghih, an employment attorney here, a expert in all things employment contracts. In fact, Leiza is a board certified attorney in employment law in Texas. She often helps employees resolve employment disputes with their employers. She also often litigates non-compete disputes in courts. Prior to opening her own law firm 3 years ago, she co-chaired a trade secrets and non-compete disputes section at the fifth largest law firm in the country. Leiza is also fluent in Russian and Spanish. Leiza, so happy for you to be on the show. I have been thinking about a lot of the issues that I heard you speak on a little over a year ago at the HR Southwest conference in Fort Worth, Texas. So excited to kind of dive in. Of course, our disclaimer here is that our conversation is not legal guidance, not legal advice. If anyone wants to dive in deeper, I'm sure they can reach out to you, consult with you, engage with you further for legal advice, because this is just a conversation about issues in the employment law space.
That's right. Thank you for having me.
So I kind of want to dive in, like, what's the state of the field of these pay or stay agreements? Can you tell us a little bit about us, catch us up to speed about what's going on in the world of these like repayment agreements?
Yeah, so I mean, they've been around for a while, and some industries use them more than others, healthcare industry, aviation industry. One of the industries that justified by saying, look, we provide a lot of training to employees, and so we want to make sure that we recoup our investment and we want them to stay on the job for a certain period of time. And if they leave earlier than that, then they have to repay the cost of training. So the agreements vary wildly in terms of how long you have to stay, how much you have to repay, what sort of training you're provided. And I've seen them used for jobs such as pet sitters or pet groomers. We're talking about people that are making minimum wage
Sure.
or a little bit more than that are required to repay thousands of dollars. I've seen nursing agreements that have those repayment provisions, very, very popular. And some other industries where employees are very highly compensated. And so they have restrictions. I mean, those act as restrictions. If you want to leave, you're going to have to repay a certain amount of money to the employer. So those agreements, I don't want to say they've become more popular, but I think in some industries they have. And the law looks at those agreements as, generally speaking, whether they're reasonable, right? And so reasonable, well, I mean, the employers think everything they put in the employment agreement is reasonable, and employees think a lot of provisions are not reasonable. But I think what employees need to understand that once you agree to those restrictions, if you want to fight them down the road after you signed such a pay or stay agreement, you're going to have an uphill battle.
Sure. And that's when they bring you in, I'm sure. So the It seems like these agreements, when I heard you speak at least last year, it seems like these types of agreements were really being debated at the federal level. And again, that was last year, October of 2024. So lots changed federally. You know, has there been any statements at the federal level of change and review of these? Like, what was the state in 2024, and where are we headed with how the federal government thinks about repayment agreements?
Absolutely. So back in October of 2024, when I spoke at the conference, we were kind of in flux. The FTC was, considering this rule that would ban all non-compete agreements. One could make an argument that this repayment provisions, pay or stay agreements, that they're kind of a non-compete because they limit your ability to move from one employer to another.
Sure.
So at that stage, we're kind of in flux. I think the rule was already proposed, but it hasn't become final yet. But I think it needs to be very, very clear. The ban that every newspaper, every news story was about, it did not go into effect. So there was a lot of information at that time saying non-competes are done, the federal government has banned them. That has not happened. Before the rule could go into effect, before the ban could go into effect, a couple of federal courts have stopped it from going into effect. And we have since we had the administration change, the new administration is taking a different approach. So the original ban was kind of proposed and pushed through the Federal Trade Commission. The Federal Trade Commission at that time was chaired by a different person who wanted the ban to go into effect. She's gone. So we now have a new chair. We have some new members in the commission, and they're no longer pursuing a complete ban on non-compete agreements, but they have issued a guidance recently saying that we are going to look at the agreements to see if employment agreements are unreasonable in terms of limiting employees' mobility. So we recognize that there is an issue, but we're not going to ban those agreements.
Yeah.
And they go through the guidance. And if anyone wants to look at it and read it, it's a legal document. I doubt anyone wants to, but if you do, I can send you a link. It lists the priorities. And so what
Okay.
they're saying is we're going to focus on these things. We're going to focus on one of those things is pay or stay or training repayment agreements, which are commonly referred to as traps. Yeah.
It's a
Yeah.
good
So
acronym.
you can guess who came up with that. I mean, plaintiffs' lawyers, they're trying to find these agreements that represent employees, but it's another way to refer to training assistant repayment programs. So they're saying, we have 10 things that we're going to look at. We're going to look at whether non-compete agreements, your classic, hey, you can't go work for a competitor, whether those are reasonable. We're going to look at repayment programs, but it's going to be employer by employer type of situation.
Okay.
So what I'm guessing they're going to do is, if somebody reports or they find out that a big company is doing this to hundreds and thousands of workers, making them sign some egregious repayment agreements, that perhaps the federal government will then file a suit against that company and get them to remove those repayment provisions from their employment agreements. That's typically what they do. If they find
Okay.
like a massive violation on a big scale where they can make an example out of that employer, Federal Trade Commission can file a lawsuit and fight with the employer and get them to remove those restrictions from the contract.
Okay, that makes a ton of sense, and the words I'm hearing is really, like, the standard here is kind of like, is the agreement reasonable? So that's kind of how you're reviewing it when you're advising clients, whether on the company side, when they're creating these agreements, you're looking for, is this sort of a reasonably related to the training, reasonably related to the benefit that the employer is providing the employee? Are there other sort of ways you look at those contracts to sort of assess reasonableness?
It's really what value is the employee getting out of?
Got it.
Well,
Okay.
first of all, so what are times when the employer says, I'm going to train you on something,
Yeah.
right? Did they actually provide training? And are we talking
Okay.
about how much of that training, how often, how valuable the training was? Because in the lawsuit where I represented some pet groomers, the training were YouTube videos.
Yeah, not
And
much value.
so not much value. And the amount that the employer wanted for the employees to repay, they wouldn't even make minimum wage. So there were a ton of issues. I mean, this was patently unreasonable, which is why I try to help those individuals. But
Yeah,
if an employer has this type of program, I mean, generally speaking, again, because each state has their own laws on what they consider reasonable with respect to non-compete restraints.
yeah,
Again, this stay or pay or training repayment program, those could be considered a type of a not compete. So some states may have their own requirements. And if people are listening to this podcast from different states, they need to realize that each state has different requirements or may have different requirements. So, but generally speaking, the employer would have to prove that they provided training. So have some sort of a record and then have some sort of explanation as to how the amount that they're asking for the employee to repay is related to the cost of the training or the time spent in the training. They have to have an explanation. And then I think also a lot of times the problem is that once you sign the agreement and receive the training, it doesn't matter how long you stay in that position, how early you leave. If you leave within 3 months or leave within 3 years, you still have to repay the same amount. That can also be another problem because if you stayed there for 2.5 years, but didn't make the 3-year mark and you still have to repay the full amount, arguably that's not reasonable.
okay,
So those are kind of common sense
sure,
arguments
yeah.
that employees make when they try to challenge this type of repayment program.
That's super helpful, and the way this comes up in my practice is often when employers are sponsoring employees for green cards, they approach the employee with a pay or stay or repayment agreement because the investment in the green card process can get quite pricey. So often when I'm counseling my clients, I say, like, it's a good conversation to have so the employee understands, like, the value of the investment and the benefits that they're receiving. But I always say, like, you need to have this contract reviewed by your state certified, state barred employment attorney, to your point, to make sure it's meeting the state qualifications requirements of reasonable. And I see these contracts are often drawn up by HR with the intent to sort of protect the company, which makes sense. But like we could be getting into some unreasonable grounds to your point about if they have to repay the whole, legal fees of supporting this, even if the employee stays for 2, 5 years, like, we wanna make sure that, like, it's not this forever agreement. So that's interesting because I see all sorts of different things, and they ask me to review, and it's like, that's where I say, "Oh, that's an employment contract. You need to have that reviewed, by, someone who's qualified in your state." Because there's often these conflict of laws that I see, like, immigration's at a federal level, and we were sort of saying, like, what's the FTC? That's sort of federal guidance, but to your point, like, states can make different requirements that can put state liability, whether that's, civil or whatever there.
You're right, 100%. Federal law lays the floor for employment rights, right? And
Yes.
then the states can add on to it. And so, like California, Colorado, New Jersey, I mean, those are jurisdictions that added on a lot to what the federal floor provides. Texas
Sure.
is at federal floor. I mean, every state, I think, including Texas, have tried to pass some sort of limitations on non-compete agreements, but in some states they've succeeded, in other states they have not. So it really non-compete restraints and a lot of what you can and cannot put in the employment agreement or what you should put in the employment agreement in order to make it enforceable, that's a state law issue. And
Got it.
so employers really need to and employees, I mean, regardless, need to talk to the lawyer in the jurisdiction that would apply, in case there is a dispute. Because at the end of the day, the reason you want an employment agreement is that if there's a dispute, this is gonna really, really come into play. And the
Sure.
language is really important, especially with non-compete agreements. I have employees call me all the time and ask my advice on the non-compete restraint. And I say, first thing I need to do is see your agreement because the language, I mean, all the facts can be the same, but the way it's worded, where it's placed, how it interacts with other provisions in the agreement, that's number one. And if you end up in court either fighting the agreement or enforcing it, you're going to show the contract to the judge, and then the judge is going to look at the language. So the language of the agreement is very important, not something that should be carefully considered. Let me put it this way.
Yeah, no, that makes a ton of sense. How often do you see employers, like, pursuing, enforcement of these repayment agreements? Is that pretty common or kinda depends?
Um, well, how do I? Well, I like to use this example. I'm like the emergency room physician. I only see bad cases. Like
Okay.
you're not hurt. I'm not. I'm never going to see you. So I cannot tell you what percentage of the agreements get enforced because those who are not enforcing them, who are not demanding repayment, I never see those cases.
Sure.
But I see them fairly often. And like I said, when you sign something like that as an employee, you have to consider that you're gonna have to repay it. I mean, maybe there's a hole in the agreement, or you may have a defense to the agreement. Maybe there's some exception why that would not be an enforceable contract. There are those situations, but you would be spending money on attorneys trying to find that hole and fight the contract. So I do see employers, especially if they made a substantial investment, asking for their repayment. I've also seen, with pet groomers, employers just abusing this agreement. I mean, that's
Yeah.
not abuse. It's just a pure restraint on someone to make them stay. Kind of using it as a scare tactic.
Right, because the repayment is just so high, that person can't possibly repay it in the new role that they're, like, looking to move to, given their wage. That's what you're sort of
Yeah.
suggesting there? Yeah.
Yeah, and they feel like this is abuse, but they're not sophisticated enough to know what to do about it. And so it does unfortunately limit their employment opportunities unless, somebody tells them, hey, contact a lawyer and try to fight it. Or, most I feel like from my conversations with several individuals in that industry, they do feel like it's restricting their employment opportunities. They're scared
Sure.
that the employer will come up to them.
And then you're like, "Let me see the contract, and then we'll go from there." Right?
Yeah. Well, in that situation, I mean, I mean, I don't even need to see a
Oh,
contract. I
really?
mean, the amount of the repayment given their wages, I mean, it's just outrageous. But
Sure.
that brings me to an interesting lawsuit that I saw a few years ago where a nursing company who brought in a lot of nurses from the Philippines was using those repayment provisions in their contracts. And the New York State Nurses Association filed a class action against them. And in that situation, it is very restrictive. So I'll read you from the lawsuit if you're interested, just
Yeah, tell us
as an
more.
example of what not to do.
Yeah, no, that's how we learn from others' mistakes.
Yes. I like that quote. That, smart people learn from other people's mistakes.
For sure.
When I see lawsuits that are filed by other attorneys in other jurisdictions, even if it's not 100% applicable to what I do, I try to read them to see what ideas I may get, either on plaintiff or defense side. So this lawsuit, they filed it in 2019, and I'll just read you a paragraph because it's a really good summary. It's the second paragraph in the lawsuit, so it tells you exactly what the lawsuit is about, and it's against Albany Medical Center, which they call AMC. And so this is what plaintiffs write. AMC has recruited 582 nurses in the Philippines to migrate to the United States and work as registered nurses at AMC. In order to enter AMC's program, however, those nurses who make as little as approximately $50,000 per year before taxes — I've heard taxes in New York are high. We don't have a state income tax in Texas. Those nurses who make approximately $50,000 per year before taxes must sign a contract obligating them to immediately pay up to $20,000 to AMC should they resign their employment within 3 years of their start date. So you give your employer a termination notice and you immediately got to fork over 20 grand when you make 50 grand before taxes.
Yeah, how would you do that?
Yeah. And then the contract that this immigrant nurses must sign in order to obtain employment and come to the United States threatens that AMC will seek to automatically enter judgment without so much as a lawsuit should they resign and fail to repay. So I don't know if they actually sign a judgment that gives AMC a right to file it with the
Oh.
court, or if that's just a threat in the contract. But I mean, that's pretty aggressive.
Yeah, that feels egregious to include that threatening language as opposed to just sort of, "Here's the payment, here's the term." But even like you said, the payment, 20K, is almost half of their salary, like, so that's sort of when we think about reasonable is a big red flag for sure.
Right. And it's at any time during the 3 years. So, like that example that I was giving you. So, somebody works for them for 2.5 years. I mean, that's a long period of time,
Right.
no matter the training. And they still have to pay $20,000. So, you can imagine, if you're in their shoes, how restrictive that would be if you want to switch to somebody who, for example, can pay you higher, allow you to spend more in your family, upgrade your lifestyle, and you can't because you immediately have to pay $20,000 or face a lawsuit. And another interesting thing about this lawsuit, which what drew my attention, is that one of the claims that they bring in here is that the employer, AMC, violated the Trafficking Victims Protection Act.
Wow.
Yeah, so that's a federal statute that addresses human trafficking. And in this situation, they were alleging that these restrictive agreements combined with some other practices by the employer basically were creating debt bondage that
Wow.
you can never leave, because you
Yeah.
always owe that debt.
Yeah, no, I mean, that kinda makes sense, especially, like, when you're sort of making them sign this before moving them, to the US and then sort of keeping them in that role. Yeah, I could definitely see that. And how scared these nurses must have been to bring a lawsuit given what they're up against, like loss of significant wages and probably the threat to return back to the Philippines, right? Like, that's sort of
Yeah.
what's, almost the only other option on the table for them. What a good case to bring up. Thank you. We sort of talked about the reasonable standards, and it's kind of like, yeah, like, term of agreement, amount of agreement, and that is the employee receiving something of value. So those are things to sort of think about and prompt for an employer who's looking to have the contract reviewed or an employee looking to have the contract reviewed. Those are some of the questions you probably want to prompt with the reviewing attorney. Does that sound right?
Yes. Yes. Mhm.
Amazing. Okay, I kinda wanna turn to the non-compete agreements. So you said how, like, the repayment agreements are related to the non-competes, and this is what was in the headlines all of 2024 under the Biden administration's FTC. So tell us a little bit about, like, non-competes specifically, and where are we with the FTC on non-competes these days?
The ban has been in discussion from the federal government for many years, 3 or 4 years. They studied the problem, the Federal Trade Commission. They had held workshops. They received 30,000 comments from people and organizations about whether the non-compete should be banned or not. And then last year, they finally issued the proposed rule, banning all non-compete agreements with the exception of there was a very, very tiny carve out, and that So basically, they said, remember how I said federal law sets the floor? They were going to just, no matter what the states decided, the federal law was going to trump it and say all non-competes are banned. No state can have a non-compete agreement, with that small exception that they wrote into the rule. 3 hours after they announced that rule in public session, we already had a lawsuit on file in Texas.
They were ready.
I mean, for lawyers, this was expected. For lawyers that follow this area of the law, like we're reading the headlines, so like, okay, this is, the U.S. Chamber of Commerce, even when the Federal Trade Commission was considering the ban on non-compete agreements, before before the U.S. Chamber of Commerce even knew what that proposed rule was going to look like, they already said, we're going to sue, we're going to stop it from going into effect. And so, yeah, so this was not a surprise. We had a lawsuit filed by them. We had a lawsuit filed by an accounting firm in Texas. There was a lawsuit in Florida, and I believe in Pennsylvania. So almost immediately there was a reaction to that proposed rule. And there were some valid arguments against it, because I mean, just a complete ban on those agreements. The argument from those saying the ban should not go into effect was that you haven't really provided a basis for why a complete ban is the only thing that would work in a situation like that. And so the federal courts, there were numerous arguments that I'm not going to get into because it's super legal analysis that would bore anyone who's not.
I'm interested. Yeah. We'll take a
So,
sidebar though. Yeah.
yeah, it came down to whether the Federal Trade Commission has the authority to pass a rule. And so one
Got
of
it.
the arguments was, look, Congress has tried to ban non-compete agreements on the federal level several times. For many years, different senators, different representatives introduced various federal statutes, not necessarily a complete ban, but some variation of, we need to address this problem with non-compete agreements on the federal level, and it never got anywhere. So the argument was, look, it's legislative, not we can't have a federal agency consisting of 5 people
Sure.
deciding what really should be a law that should be voted on in Congress. That
Okay.
was basically, in a nutshell, the biggest argument. And the federal courts generally agree that yes, just if you want to pass a law banning all non-competes, all good and proper, but go through Congress, not through a 5-person, federal agency where we have a change in administration and the 5 people have changed. So it's
Sure.
not the same, not a proper way to do it. Let's put it this way.
Yeah, so more of a rulemaking process, procedural reason why the FTC can't ban federally the non-competes, because there are some states that ban non-competes, right? Like in California, you cannot be subject to a non-compete. Um,
Correct. But all
right.
those things go through their legislature.
Right. Yes.
So they are doing it the right way, I guess the argument would be. And so, but that's what I'm saying also, that you have to know what the law is in the jurisdiction, in the relevant jurisdiction, because California bans non-compete. Texas enforces them daily. I had a lawsuit last year where the judge on the bench said, I enforce the non-compete agreements every week, And
Yeah.
so it varies widely whether they're going to be enforced or not.
And the intent behind these non-competes for the company's purposes is to protect proprietary information, to protect like the company's secret, confidential information, right? Like that's kind of the non-legal answer to like why companies would want these agreements in place.
Well, in Texas, it's usually 3 reasons.
Okay.
It's the trade secrets and confidential information, that we don't want you to go work for our direct competitor and use all the knowledge that you obtained about our internal, information that's not publicly available for the benefit of our competitor. It's also goodwill of the business, which is, that's a lot of arguments about that in the sales positions,
Oh,
because
sure.
if you're a very successful salesperson and you want to switch employers, are you benefiting from the goodwill of your employer? Where let's say you
Mm,
work for Johnson and Johnson or some really GE, some really well recognized brand, and you worked in the sales position for them for a long time, built up all of these customer relationships. Was it because of your personal goodwill, or was it the goodwill of your employer? I had a neighbor who worked for a very big corporation, and she was selling certain equipment. And she said, look, whenever I call and I say I'm from that corporation, my sales job is easy. I don't have to explain who they are. I don't have to explain what they do. People know the brand, they know general the reputation. And so, it's much easier to sell for them than if I go to a smaller company. I may make more money potentially, but I'm going to have to work a lot harder.
Sure. Sure.
Not just sell the name of this neighbor or the company, but
Yeah.
this is just, out of horse's mouth. The salesperson was telling me that it is the goodwill of the employer, the reputation of the employer that is benefiting them. Of course, a lot of salespeople will say, "No, it's me, it's
Of
my,"
course.
right? Well,
Yeah.
yeah, I mean, I
Yeah.
would argue the same thing if I was a salesperson. It's my personal charm and skills and, sales abilities. The employer's name has nothing to do with it. So it's but that's how employers justify it. Look, if you're working for us, we want to non-compete because we don't want you to use our goodwill for a certain period of time after you leave us. And then the third thing is training. If we provide
Mm.
training, specialized training especially, then we want, to recoup that investment for a certain amount of time.
That makes a ton of sense. And that I'm so interested in this because I represent a number of companies that utilize non competes. And so they are New York based proprietary trading companies. And it makes sense. They have a lot of very specialized codes, specialized algorithms that they want to protect. And they don't want employees to just sort of port that information, that knowledge to to your point, like direct competitors. And so I see this in the immigration space because I'm representing a company that wants to hire that person that's subject to the non compete. We get into these sort of really deep theoretical discussions about how immigration, federally practiced, interprets a New York State employment contract, someone's subject to a non-compete. And, in our prep call, I would normally sort of defer, say like, oh, you got to talk to the employment law attorney. But in our conversation, it sounded like maybe it's the immigration attorney's call about how the individual maintains status. So we'll dive into that in a little bit. But I want to hear more about the state of non-competes and, are companies still reliably using them given that this is sort of off of the FTC's sort of priorities or agendas under the Trump administration?
Right. I mean, look, non-compete agreements are still alive and well. They're still being used despite, the headlines. I saw yesterday someone on LinkedIn posting that FTC banned non-compete agreements, and I'm like, that is misinformation. Please do
Are
not
you commenting?
Or
Yeah.
yes, I commented. Or I just do tell people and then I'll have more work. I don't know, how responsible to say that they're banned when they're not.
Yeah.
Again, you have to look at the jurisdiction. And I have a Google alert on non-compete news, and so I see the headlines. New York, is changing their non-compete laws or is trying to change them. Wyoming, I think, just either banned or is planning to ban their non-compete agreements. But you have to read beyond the headlines. Okay, so if people are researching this issue, don't just read the headline. The headlines can be misleading.
Yeah.
It happened a lot with the FTC news. There's a ban, but the ban is not effective. It has not happened, and it was stopped before it went into effect. So in reality, it was a potential ban, never became an effective one.
Right.
But I saw a lot of headlines that were misleading, and you actually have to read the article to understand that, wait a second, the headline and the body of the text don't align. So alternatively, if you don't want to, read the article, just I would say gotta talk to a lawyer in the jurisdiction that you're in to figure out, hey, what's going on here where I am in terms of non-compete restraints, you know?
Yeah, and then what does the state consider reasonable, good faith contract language to use in that agreement, right? Because it's not only just like, what is the state? Can I even have a contract like this?
Yes.
It's also like, what is enforceable language in that contract? Am I understanding that correctly?
Yes. And he also a lawyer, and I'm not touting my own horn, but I just want to give an example. So when I worked for the national firm that had offices everywhere, I used to follow non-compete changes everywhere. Now I don't do it as much because most of my clients are here in Texas. But at that time, I remember we had an issue in New York, and so we had to do research on whether certain non-compete was enforceable or not. And so there was a drastic difference that you would not know from just looking on the internet. While the statutes were at that time somewhat similar, that the non-compete has to be reasonable, there was a major difference. In Texas, if you get fired, your non-compete is still enforceable.
Okay.
It doesn't matter if you're fired or if you left on your own. The reason for your termination of employment is irrelevant, uh, generally speaking. I always leave a room for an exception.
Yeah, there might be some exceptions, yeah.
Generally speaking, that is the rule. In New York, the courts, not the statute, but the courts have said that if at that time, okay, this was a few years ago, so might have changed completely. Don't take that as legal advice. But at
Yeah,
that time in New York, the courts have said, well, if you're fired, it's unfair to enforce your non-compete agreement because it's not your fault that you were let go.
interesting. That's a huge distinction.
Yes. So you would not know this, and I doubt, unless you stumble upon a legal article that someone had the desire to put out on the internet, and had a right legal analysis for you. I mean, you would not know that unless you talk to a lawyer who hopefully knows the law in that area. And so that's I always kind of caution people, like, just talk to a lawyer. It'll save you so much trouble.
Yeah, because what I worry, especially like a lot of my listeners are global mobility HR leaders, that they'll maybe consult the internet or, chat GPT to get a quick answer. Because sometimes it's like they need an answer to provide to another HR leader. And yeah, I mean, it sounds like the LinkedIn post could have come from chat GPT, like, write me a post about the state of non-competes, and that like right? Like, their analysis of the headlines would be like, "It's banned," and it's like,
Right.
"No." I'm so interested in these employment law issues, again, because when my clients are subject to a non-compete and they're an H-1B worker and they wanna work for my company, we discuss, like, is the H-1B are we maintaining status? And so, again, not giving legal guidance, but we really have to look at it, and often what's happening is I'm being brought into these conversations sort of 6 months after the fact where you can't change the facts, right? And I know you have cases like this, and you're like, "Oh, man, like, now I'm gonna have to defend a decision that arguably might not be compliant," and so we have to sort of come up with it and, things in immigration, maybe the risk is low for enforcement, although maybe not these days, but the consequences are very dramatic. So it's really hard to sort of assess risk in those situations where, like, maybe it's a 5% chance of discovery or 5% chance risk of non-compliance, but that means you're removed from the US or you have a subject to a 10-year ban. Like, it's quite high. And so when companies are using the non-competes for H-1B workers, they're not counseling the H-1B worker when they voluntarily leave what their immigration compliance is. So this is really just my shout out that if you are one of these companies that uses non-competes or you're an H-1B worker, it's like you have to understand what the immigration compliance is and how state contract law doesn't give you an out. That you
Right.
were subject to a non-compete. The US government, from an immigration standpoint, like, doesn't care. So, you have to be really mindful of that. Um, in our conversations, Lisa, I now understand that this maybe is more of an immigration issue than a employment law issue that I've been kinda ducking, I guess. Like, "No, talk to the employment lawyer on this."
Yeah, there's certain federal laws that you just can't do away with in an employment agreement. You
Yeah.
know, even if you and the employee, as an employer and an employee, agree to certain things, you can't agree not to comply with federal law, I guess.
Right. Yeah, that's not a enforceable contract term. Yeah.
Right, right.
Um
It's like just two different issues. Yeah.
Yeah. Well, it sounds like there's probably more to come in the state at state levels regarding the state of non-competes. Can you tell me about like when state legislators are like looking to either restrict non-competes, like what advocacy groups are pushing for that? Like, how does that even get into like a legislator's agenda?
Let me talk about just generally who was for and against the ban on a federal level. And I think
Okay,
that will
perfect.
give you an idea of I'm sure it's similar interests that are involved at the state level. I think most, let's say, U.S. Chamber of Commerce, American Medical Association, like think of really the Restaurant Law Association. I mean, think of all the like big lobbying groups that represent businesses. Those are the ones that spoke um, against the ban on non-compete agreements on the federal level. So businesses are generally against non-competes. The trade associations or associations that represent both owners of businesses and, let's say, like American Medical Association, you have members who own healthcare practices, and you have also your rank and file doctors, right? So you kind of have conflict here. Doctors
Yeah.
don't want non-competes. The owners of healthcare practices obviously want them, and hospitals want them. So the association will usually defer, in my past experience, from what I've seen, to, let's maintain the status quo. Let's not change what we have right now. So basically, they're against the restrictions. And then, of course, employees, all employees. I mean, out of 30,000 comments, you probably can think like 25,000 were from individuals who got stuck with a compete at some point and had a painful experience. And so, they're, of course, they're always saying, you got to get away. You got to get away from that. But,
Yeah.
but generally, then also you have to think about all the private equity activity that's going on out there, right? Certain industries, I mean, they're buying out, healthcare practices, they're buying out vet practices, right? I mean, those are becoming, so there are certain industries where private equity has identified as low risk, high reward, and
Yeah.
they're slowly acquiring businesses in those industries. And one of the first things they do when they buy a business is they sign, make everyone sign non-compete agreements. Actually, they won't buy a business if the
Right.
individuals won't sign. So, how much money private equity has and how much power do they have? Um, and how much are they behind the scenes in trying to prevent the ban on non-compete agreements? I mean, if you think about all the healthcare practices in Texas, and I think New York, I mean, every state has experienced it. I don't know to what degree, but we had so many healthcare practices being bought by private equity funds, um, and they're making everyone sign non-compete agreements. They would not invest into a business without that. And so I don't see them um, just, sitting on the
Right.
sideline watching those bans going into effect. So that's just my maybe a conspiracy theory, but it's
No.
the reality. I mean, I sat on a plane next to a guy who was flying from New York to Texas because he worked for a hedge fund or a private equity group. I don't know the name, but they invested in healthcare practices, and he was going there to meet, and we were talking about it. And I told him that I've litigated against private equity funds on the non-compete issues brought by former employees, and he started laughing. He's like, "Yeah, we're not gonna invest in any business where they don't sign non-compete." So I'm like,
Yeah,
"Yeah."
protecting their investment, like, that's a way to protect the investment. Man, private equity is behind everything. I also read a headline that they're buying up childcare centers now, and it's just like they're kind of in everything these days.
Ooh.
Anyway,
I did not know about that, but that doesn't surprise me.
yeah. No, that's interesting. Thanks for sort of sharing it because it's always like what players have what interests and, why are we seeing turns in the federal state of things? But it sounds like it's in flux and really looking at the state level is really important as far as, from an employer side, can we have these agreements? Can we enforce these agreements? What language needs to be in them? So this is really just, it needs to be reviewed at a very specific, thoughtful level with an employment attorney at each state. So,
Yeah.
yeah.
I know, that's probably not the answer that everyone wants to hear, but, look,
It's the right one. It's the right answer.
if you wanna make sure that you don't end up in big trouble or spend a lot of money down the road, right? Because that's a consequence of every mistake that you make is you're gonna end up spending a lot more money down the road.
Right,
Really,
right.
um,
Yes, totally, and that's what these agreements are meant to protect is to protect or limit exposure or expense, so it makes sense you gotta pay up front to have it reviewed so that it can be, enforced in appropriate ways, if that's the intent.
that's right, and the cost up front is, minuscule in comparison to what you pay when you end up in a lawsuit on either side. Either you have to enforce the agreement or you end up fighting it on the other end as an employee or as an employer, you're trying to enforce it, you're gonna,
Right.
you know, what
100%. Well, thanks for sort of walking me through all these issues. I'm, again, super interested in them, so I'll be following you. I know that you post a lot on LinkedIn and you have a blog about these legal issues related to non-compete agreements. So we'll drop links for how folks can follow you on LinkedIn, subscribe to your blog to learn more. Any sort of final thoughts on non-competes in the federal arena or Texas, your state that you're practicing in?
my only I mean, just to, like, underline what I've been saying is there's a lot of misinformation on the internet. There's a lot of outdated information, and there's a lot of information that is just outright, flat out wrong. And so if you're researching the internet and, you grab and you rely on the first or second or fifth article that you've read about it, you're asking for trouble. You like living on the edge, you like to gamble.
Fair enough. Yeah, no, thanks for offering the nuance, the thoughtful sort of framework in which to sort of view this issue. And that, yeah, again, to sort of conclude here, you're not going to get thoughtful, accurate legal guidance unless you talk to a state certified employment lawyer on these issues. So thanks for sort of giving us high level, some interesting case studies of what went wrong. Um, in the state. Really appreciate you sharing your expertise here on the business immigration benchmark. Thank you, Lisa.
Well, thank you. Happy to do it.